Hello everyone, my name is Gabriel Avigdor and I'm a Swiss qualified attorney specialized in technology and privacy. So today I would like to discuss briefly about the Schrems II case and what is its consequence immediately for companies. So today, 16 July 2020, the European Court of Justice issued its ruling that was a long-awaited decision initiated by the privacy activist Maximilian Schrems, an activist who was questioning personal data transfer from the EU to a third country, a country that was not providing an adequate level of protection for the individuals. And today, in this decision from the European Court of Justice, it was decided and considered that Privacy Shield is deemed invalid. You may remember that Maximilian Schrems already questioned personal data transfer to the USA in a Facebook case back on the basis of the safe harbor. And the safe harbor was deemed invalid as well in 2015. This is why the Privacy Shield had replaced safe harbor, but now it becomes invalid again. Also, in this decision, the European Court of Justice is still considering that when you transfer personal data to a third country, based on the Standard Contractual Clauses, this mechanism is still deemed valid. However, the European Court of Justice considers that to be valid, it is the responsibility from the exporter of the data to ensure that when the data is sent to a country that does not provide an appropriate level of protection, that the exporter is assessing whether the legislation of the country is providing the necessary tools so that we can respect the rights and freedoms of the individuals from EU, which is something that is going to be very difficult to demonstrate in terms of accountability. This is both the responsibility of the exporter, but also the responsibility of the importer, which is a massive change in how we were dealing with SCCs, Standard Contractual Clauses, in the past. So now what is the consequence for companies with this decision today? Well, today, all the companies that are relying only on the Privacy Shield cannot transfer personal data to the US based on the Privacy Shield. This transfer is today illegal. Now, still, a lot of companies are relying on the Standard Contractual Clauses to share personal data from the EU, potentially from EEA and Switzerland, based on the Standard Contractual Clauses. This mechanism still remains valid. However, it might be that for a transfer to one country, such as USA, but others such as China, India, or other countries which are considered as third country, someone contests the validity because it considered that this transfer is not valid because the country that is importing the data is not considering as having a level of protection that is sufficient. This is likely that it may happen because we see that Maximilian Schrems is an activist and is going to probably contest other countries' legislation. However, today it still remains valid and the companies can still rely on this mechanism. However, it is up now to the GAFAM to find ways to potentially put the data back to Europe in data centers in Europe, or even to the authorities, data protection authorities and the European Commission to decide what to do and how to make probably an amendment to the Standard Contractual Clauses, and also maybe to provide a list of those countries that is updated. For Switzerland, it is very likely that the Swiss Federal Commissioner will update its decision to say that it will not recognize anymore the Privacy Shield as a valid legal basis for transferring data outside Switzerland. However, companies in Switzerland can still rely on EU-approved standard contractual clauses or other approved mechanisms by the Swiss Federal Commissioner. So this is all for today. Thanks for watching, and I see you in the next video.